My name is Ira Smith, President of Ira Smith Trustee and Receiver, Inc. First, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure during this coronavirus pandemic. Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are holding all meetings either by telephone or video, and we are available to answer any questions you may have about either this Brandon blog or anything else at all. So give us a call, shoot us a message. We would love to speak with you. Today's Brandon blog is titled, "What Does Bankruptcy Discharge Mean for One Bankruptcy Trustee and Someone Who is Seriously Bankrupt?" Brandon discusses the two forms of discharge in any personal bankruptcy administration: the discharge of the bankrupt and the discharge of the trustee, and what does it mean for each of them. So I hope you can watch until the end of this video, because I know you will get value from it. This Brandon blog came about because of a recent released decision in bankruptcy court in Nova Scotia. And it has to do with the discharge of the trustee. Now, there's really nothing remarkable about the case itself until the very end. The registrar in bankruptcy goes through a very good analysis of what it means for a bankrupt who did not get their discharge, but for the trustee about to be discharged. And at the very end, the registrar did something very special, unusual, but special in a good way. So Brandon, in his blog, first discusses what are the restrictions placed on an undischarged bankrupt. Then discusses what does it mean to be an undischarged bankrupt. Third, he talks about debts that are eliminated by a bankruptcy discharge and stresses that it's not the act of filing for bankruptcy that eliminates a person's debts. It is when that person gets a discharge from bankruptcy, it is the discharge process that actually eliminates the debts. Brandon then discusses how bankruptcy law can resolve income tax debts. He then talks about debts that can never get discharged in a bankruptcy. He then discusses the difference between an absolute discharge and a conditional discharge and goes through the four forms of discharges, identifies them, and then refers you to an earlier blog that he wrote if you wish to delve deeper into each type of discharge. And then he discusses the Nova Scotia case and discusses the unusual thing that the registrar ordered the trustee to do upon the trustee getting its discharge. Now, the bankrupt, his discharge was refused. The court refused his discharge because he failed to perform his duties. And actually, he rubbed it in the trustee and the court's face. Trustee was going for his discharge after the bankrupt's discharge was refused. When the trustee gets its discharge and the bankrupt is undischarged, the stay of proceedings that has protected the bankrupt from all of his or her creditors continuing their enforcement actions, that stay of proceedings evaporates upon the trustee's discharge, and the creditors are at liberty to again begin enforcement action against the bankrupt. The registrar wanted to make double sure that all the creditors understood this, and you will see in the blog the unusual thing the registrar did and ordered the trustee to do. So I hope you can read the entire blog because it is full of good information. Again, the Ira Smith team hopes that you and your entire family are remaining safe, healthy, and secure. Ira Smith Trustee and Receiver Inc. remains fully operational. Both Brandon Smith and myself are available to answer any questions you may have. We are holding all meetings by telephone or video. And if you have any questions about this Brandon blog or anything else at all, please feel free to contact us. Give us a phone call, shoot us a message. We would love to hear from you.